Hello, everyone. Thank you for coming. Jennifer's just got a few sentences to say about the technical issues before we start the substance of the webinar.
Hi, everybody. So you'll be on mute during the webinar, and if you've got any tech issues, please just put that in the chat. If you've got any questions for the speakers as we go, there is a Q&A function, so you can type your question in either for everybody or directly to the speaker. The webinar is being recorded, which means that the audio and the video are both being recorded. And let us know if you've got any issues with that.
Okay, so to introduce myself, first of all, my name's David Neale. I used to be a barrister specialising in immigration and asylum at Garden Court. Since 2018, I've been in a non-practising role as the legal researcher at Garden Court. And I work closely with the Migrant and Refugee Children's Legal Unit at Islington Law Centre to improve outcomes for asylum-seeking children and young people from Albania. And I'm also an editor of the forthcoming edition of MacDonald. I'm also disabled, I'm autistic, and I have a particular interest in the interface between asylum law and mental health. So, an understanding of disability needs to be part of every asylum lawyer's toolkit. If you're involved in the asylum system as a lawyer or as a judge, you're regularly going to encounter people with post-traumatic stress disorder and depression, which are disproportionately common among people seeking asylum. Sometimes you're going to encounter people with complex childhood traumas, with learning disabilities, with schizophrenia or other serious and complex mental illnesses. Sometimes you'll encounter people with serious physical disabilities and illnesses. Now, these factors have a huge impact on every aspect of asylum adjudication, but so often they're ignored by those who are making asylum decisions. For example, the psychological literature tells us that depression and PTSD can significantly impair autobiographical memory, that human memory for temporal information is often poor, and that inconsistencies are to be expected in the genuine accounts of victims of trauma. And these effects can often be particularly acute for people who were traumatized in childhood and people who've come to the UK as unaccompanied asylum-seeking children. We'll be hearing a bit more about some of those issues from Cornelius later on. But Home Office caseworkers and judges still often make adverse credibility findings on the basis of inconsistencies in a person's account. In the tribunal, vulnerable people seeking asylum are still regularly subjected to traumatic and unnecessary cross-examination, where minor inconsistencies in their account are used as a pretext for calling them a liar. People are constantly disbelieved for spurious reasons that are completely contrary to what we know about how human memory works. At worst, sometimes the person's mental illnesses are not even picked up by their lawyers and no medical evidence is submitted, meaning that the tribunal is deprived of critical evidence. And similarly, the potential importance of disability to risk on return is sometimes not fully appreciated by lawyers, caseworkers, or judges. For instance, sometimes a claim based on disability is wrongly assumed to be an Article 3 medical claim, so-called, when in fact it should be considered as an asylum or humanitarian protection claim, because often the real gravamen of the claim is not just the lack of healthcare, but also the risk of serious ill treatment by state or non-state actors because of disability. We're going to be hearing more from Ali later on about when a disability might be a particular social group in its own right under the Refugee Convention, and when disability might found an asylum claim. And of course, disability can also serve to enhance risks that one faces for other reasons. I often say that a legal education teaches you what a quis-close trust is and how to address a circuit judge, but it teaches you very little about mental health. For everyone who works in immigration and asylum law, mental health literacy is essential, as is an understanding of how both mental and physical disabilities can affect an asylum claim. As a profession, asylum lawyers really need to get better at this. Now, I've been privileged to work with some lawyers who are doing amazing work in this area, such as the Migrant and Refugee Children's Legal Unit at Islington Law Centre. But I think as a profession, we really need to build an understanding of disability and mental health into everything that we do. And there's just not enough mental health literacy, and there's certainly very little of it in the Home Office and often in the judicial system. So I'm now going to hand over to Jennifer, who's going to talk about the report that we've written and how it might help to improve practice in this area.
Thank you, David. So over the last couple of years, David and I, with researchers Jenny Whitaker and Savannah Dowden, have been looking at the issues of disability and asylum law. We met with the multidisciplinary team at the Helen Bamber Foundation, so that's doctors, clinical psychologists, counter-trafficking experts, and welfare specialists and lawyers. And we also looked through some of the refusal decisions from the Home Office for Helen Bamber Foundation clients who are disabled. We also looked at the kind of policy and operational guidance frameworks out there. And it seems like there was a spate of activity in around 2010, looking at perhaps when the Equality Act came into force, around the UNCRPD, the UN Convention on the Rights of Persons with Disabilities, and that since then things have ground to a standstill, basically. For example, the tribunals have a joint presidential guidance note, it's number 2 of 2010, on vulnerable witnesses and appellants, and that doesn't mention reasonable adjustments anywhere. It predates the Equality Act just and hasn't been looked at since, so it's very out of date. There also isn't any API, which is Asylum Policy Instruction, which are the guidance notes for asylum caseworkers in the UK on disability, but there are on some other protected characteristics, perhaps developed in rather piecemeal way. But that's quite stark when you think how common disability is amongst asylum-seeking populations, whether that's as a result of torture and persecution, or other difficult experiences, so to do with trauma or other maybe physical injuries, whether that's because the kind of characteristics that go to making a system less accessible to asylum seekers are part of the reason they were persecuted in the first place or made them more vulnerable to exploitation or trafficking. But that there is a high prevalence, but again and again we see very little recognition of disability in Home Office decisions and practice. So, for example, we noticed particular problems with the way that country information, which was often very generic, doesn't deal with disability at all well, and then it's just copied and pasted again and again in decision letters. Similarly, the standard of proof seems to be applied in a very high way when you're looking at people who may need extra support in establishing their claims. And for the Helen Bamber Foundation, which works with particularly complex asylum claims and kind of mental health, we have quite a high number of clients making fresh claims for whom maybe their additional needs are only identified much later down the line. And those cases are treated, as I'm sure many people listening will have experience, with a very high standard of proof and a very difficult. So the aim of our report was really to restart the conversation about disability and asylum law, and it's only possible for one report to do so much. So it's just beginning to look in a kind of general way at the issues to try and start a debate and start to get some things moving again. The report looks at the interaction between disability status and the definition of who is a refugee and the Refugee Convention. For those who might not have seen the report, I've put it in the chat, a link to it. It was also sent out today. It's also on the Helen Bamber Foundation website. So it looks at the interaction between disability status and the refugee definition, whether that's as a particular social group or as a risk factor in other asylum claims. And I think Ali Bandagani, one of our speakers, is going to be talking about that in a little bit more detail. The report also looks at the process issues and accessibility issues around asylum claims. And again, there's only really a starting point at that, looking at where we are now and looking at some ideas for where we might go in the future. And I think that's some of the sorts of issues that Ricardo and Cornelius are going to be looking at a bit in their talks. And I think the main point from our perspective is that we currently have in the UK an asylum system which fits into an immigration enforcement process where there's key touchstones on the way, but it's about establishing really if somebody is illegally in the UK or not. What we don't have is a system that starts out to address people's survivors of often very severe persecution, to meet their unmet needs, to assess risks, and to have a kind of needs-based system, which would be better for everybody. Because anyone, any of us in our lives, and most of us at different points in our lives, will be disabled by some kind of situation or circumstance to do with linked with our individual needs or medical conditions or something like that. And it's easy to foresee for many of us a situation where we would be disabled by a system or structure. And that's the system we have at the moment, a system that makes people less able to present their claim, doesn't support and lift them up to make well-founded claims. So if I hand back over to David to introduce our first speaker.
So I'm very pleased to introduce our first speaker this evening, Ali Bandagani. He's a barrister at Garden Court Chambers, and he was counsel in the recent reported case of DH on mental health as a basis for an asylum claim. So he's going to be talking about disability and asylum law.
Thanks, David. Thanks, Jenny. I'm going to talk, as David has just mentioned, about the case of DH, which is a reported upper tribunal decision from last year. The importance of this case is fundamentally, I suppose, that it affirms the supremacy of the Refugee Convention, which in the current climate, I think is important, given the proposals that are being made by this government, and in light of changes that have happened in relation to EU law. The other important thing that this case does or says is that for the first time, I think, or at least in any reported decision of the tribunal or of the domestic courts, it says that a person living with a disability or with mental ill health may qualify as a member of a particular social group. And when reading this decision, of course, it's important to separate out as far as possible the different elements of the Article 1A2 definition in the Refugee Convention. That's something which the tribunal are careful to emphasize, and it partly does so by clarifying what the correct test is for establishing membership of a particular social group, by reference in this case to the appellant's serious mental ill health. It's important, I think, to bear in mind that this case is to an extent limited or tied to the facts, and shouldn't therefore be seen as a factual precedent in any way. The approach of the tribunal is nuanced and it's carefully considered, and it will be authority for the proposition, of course, that somebody may qualify for membership of a particular social group, even if they do not, in fact, possess the characteristic in question. So like all other convention reasons, the convention characteristic may be real or perceived. So the claim for protection under the Refugee Convention is not diminished in any way if the person is only perceived as possessing the characteristic here, physical or mental disability. So, for example, a person that transgresses social or religious mores in a particular country may be perceived to be, or may be treated as if they are, mentally unwell. Or, for example, whilst albinism is not necessarily a disability, the point is that it is treated as such in some countries, for example, in Egypt. So what if mental or physical disability is the reason why someone fears persecution? How do they establish in law, firstly, their membership of a particular social group? Well, what the tribunal says in DH is that there is a alternative approach. You can either establish what's called you could apply the protected characteristics approach, which is one developed from North America. And that means identifying an innate or immutable characteristic that in this context will be a condition which has been there since birth or which has developed over time. And the alternative approach is the social perception approach. And that means that you are a member of a group in question which is perceived by society as in some way distinct. Up until this case, it was common practice in certainly certain tribunals around the UK to apply those tests as if they were conjunctive. So you would have to establish both elements. And that's a reflection of the qualification directive. And what DH makes clear is that that conjunctive approach should not be followed. And any tribunal, reported tribunal decision which says that there is a conjunctive approach should not be followed. And the basis on which it reached that conclusion was first and foremost the opinions of all their lordships in the case of Fauna, neutral citation 2006 UK HL 46. The UNHCR position, which is dated 2002, and that is actually helpfully annexed to the decision in DH, and also by reference to the correct approach to interpreting an international law instrument like the Refugee Convention. So the reason for just going through that is to explain that one of the benefits of DH is now that it will be easier where your client has physical or mental ill health. It'll be easiest to establish membership of a PSG because you will no longer have to demonstrate both an innate characteristic and that you are perceived to be as distinct as part of a distinct group by society. You need only establish one or the other. So what did DH say about mental illness as a PSG? Because of the facts of the case, as I've noted, it didn't really go into too much detail anyway about physical disability or physical disability as distinct from having a serious mental illness. So according to the tribunal, what you should be looking for is what it calls, quote unquote, serious mental illness. And obviously, as the tribunal point out, paragraph 44, if an appellant claims to belong to a PSG based upon their mental health, there must be sufficient cogent evidence to enable a clear finding to be made. So that goes without saying, of course, there should be cogent expert medical evidence in the case. And the tribunal used the term serious mental illness as in its view, because there are a number of mental health issues which can in themselves vary in degree, but which enable a person to function without any obvious external indicators or risk factors. Now, that's also a relevant consideration when looking at other elements of Article 1A2, specifically, and in particular, causation and also risk, persecution. The tribunal went on to say about serious mental illness that it includes diagnoses which typically involve psychosis, meaning losing touch with reality or experiencing delusions, or high levels of care, and which may require hospital treatment. The most common of which are schizophrenia, bipolar disorder, or manic depression. It is a fact-sensitive inquiry in every case. That's paragraph 44. However, the tribunal also say that the key issue is how an individual is viewed in the eyes of a potential persecutor, making it possible that those suffering a lesser degree of illness may also face a real risk. And again, emphasizing that this requires a fact-specific assessment depending on the nature of the illness, how it manifests itself, all viewed in the context of the country conditions. And that's at paragraph 79. It's also the case, according to the tribunal, that many problems experienced by those suffering mental health issues are a result of ignorance, grounded in a lack of understanding of an individual's mental health problems, and how the same will ordinarily manifest themselves. That's again at the same, that's at 79. And just on this issue, the tribunal also held, perhaps unusually, that diagnostic labels don't matter if they are explained. So the upper tribunal said that a person unable to secure a firm diagnosis of the nature of their mental health issues cannot be denied the right to international protection just because a label cannot be given to his or her condition, especially in a case where there is a satisfactory explanation why this is so. Most treatments in the mental health sector, the tribunal said, require a medical diagnosis to enable a doctor to prescribe a course of treatment, to enable the person to function as best they can. But if no treatment is available, the condition remains present and cannot be changed and is therefore likely to be immutable for the purposes of demonstrating membership of a particular social group. So what you get from that is then, firstly, the test is easier to satisfy, or should be, because you only need to demonstrate, only need to satisfy one of the two approaches. The other thing you get from that is, whilst ordinarily the tribunal will be looking for a serious mental illness, less serious illnesses should not be excluded. Thirdly, essentially what you're looking at is the nature and degree of the condition and its impact on the individual. Fourthly, that all of that must be ultimately viewed in context. The context is the country in question. And fourthly or fifthly, the diagnostic label, the form, is not as important as the substance. So where the medical evidence, the cogent medical evidence which you have, explains the symptoms as being severe and explains the impact on the individual, as well as their presenting symptoms, that will be enough. In the case of DH, he was just simply too unwell for any of the doctors who were involved in his care to reach a firm and conclusion, or if there was a conclusion, it was not the same as that held by the other doctors. So there was some disagreement. So that's really, in my view, aside from maybe getting into some of the potentially interesting legal points, those are the core takeaway points. It's important, though, I think, also to factor in that in DH, the facts were that the appellant was sexually disinhibited and was delusional, and that situating him in downtown Kabul was likely to lead to him acting in a way which was obviously going to attract attention, hostile attention, and ultimately mistreatment. And so what the tribunal emphasizes at paragraph 42 to 43 are his quote unquote behavioral traits, or quote unquote obvious external indicators. So whilst that was highly relevant on the facts of DH, that the absence of those factors doesn't preclude an individual from relying on mental ill health or physical disability as constituting a particular social group, because, as we know, persecution can manifest itself in many ways, and there seems to be no end in the ways by which persecutors cause individuals very serious harm. So one of the things I wanted to then just touch on, moving away from PSG, is this idea of causation and also persecution. So in terms of causation, if the facts are not as stark as those in DH, you'll be concerned with making sure that the tribunal or decision maker properly understands the correct test, which is of course not that the membership or the disability or the membership of the particular social group is the main or the only cause of harm, but that it is an effective one, a real one. So the persecutor may have mixed motives in causing persecution, but as long as disability is present and features prominently, even amongst other reasons, that will be sufficient to meet the causation test. And the other thing I wanted to touch on, so that might require, in an individual case, thinking a bit more carefully about the way in which a person with serious mental ill health may suffer persecution by reason of that condition. It also may require you to think a little bit differently and perhaps more carefully about the form that persecution will take. Paragraph 87 of the decision in DH, they noted the submission made that where someone is seriously unwell and may be required or may try to seek treatment in the country of return, that may itself give rise to a real risk of persecution. So seeking the help, care, protection that they need and need to demonstrate to qualify as a refugee may itself turn out to cause them to be at real risk of further harm, and that can take the form in some country contexts of being detained, isolated, chained, caged, beaten, or experimented upon. There's also the obvious point, perhaps, and this comes from cases from Luxembourg, the case of Mboj, I'm not sure I'm pronouncing that properly, which says that where an individual is likely to suffer real risk of breach of Article 3, that will not be persecutory unless the treatment is denied on a discriminatory basis. So that's another factor to consider. There's also the reality that treatment or care required by an individual, depending on their condition and personal need, won't in fact be provided by the state at all, not because of any policy on a discriminatory policy, but because of resources or because of lack of political will. And in this respect, I think this is perhaps the most interesting and maybe more difficult area of meeting the full definition of Article 1A2. And a suggested approach might be to look very carefully at the International Convention and to look at the articles contained in it and see whether the country of return is meeting its international law standards with regard to disabled people, and to undertake and to cross-reference the duties imposed by international law with the facts on the ground. Now, obviously, that's going to require expert opinion, as well as a trawl of the public domain material, including the reports produced by UN international bodies in particular, particularly those charged with looking at issues of discrimination in individual countries and compliance with the International Convention prohibiting discrimination on grounds of disability. So those are just some ideas about moving forward and thinking about how to develop arguments in establishing refugee status on the basis of serious mental ill health or physical disability. I think I'll leave it there because I think that's enough. If anyone has any questions, then they can ask.
Hi, everybody. So the questions, you'll see that there's in case you didn't catch this at the beginning, there's a Q&A function at the bottom of your screen, which you can click and ask questions in the chat, and either the speaker can get back to them or we'll have some space for a Q&A at the end as well. So thank you very much, Ali. That was brilliant. And that case is really, really important. I was so happy when I saw it. I'd like to introduce our second speaker this evening, who's Professor Cornelius Cortona, who's the medical director at the Helen Bamber Foundation and a psychiatrist. And he's a recognised expert on refugee and asylum seeker mental health. Cornelius, you're on mute, I think.
Okay, can you hear me now? Okay,
Yes.
I'm going to share my screen in a few seconds, and I hope I will be able to do that without too much help. And I'm sorry about the noises coming extraneous to me. There were a couple of things I wanted to say very, very briefly as a clinician listening to Ali Bandegani's fascinating talk, which there were a couple of things that were real music to my ears as a clinician working in this area. One was that the requirement for needing hospital treatment was less important than before. And I think that's hugely important because it is such a bad measure, given that the overwhelming majority of treatment, even for very serious mental health conditions, is in the community. And that's a change that in my experience, some immigration judges seem to be 20 or 30 years behind the times on. And the other is the issue about form versus substance in the matter of diagnosis. And I think that's particularly important because in this particular field, diagnosis may be more difficult to be certain of than others because of cultural differences, linguistic differences. Making a diagnosis in a way that is valid for that person may be slightly more challenging, slightly less of a trivial exercise than one might think. So again, I think these are bits of good news. So if I can try now to share my screen. And okay. Well, you should be able to see the whole slide. Never mind, you can't, but that'll do well enough. Can you see that clearly?
Yes.
Good. Okay, that's better. So I'm going to be talking about recovery needs in particular, and I'm going to be taking some of the implications in terms of need for international protection, which I hope will link with the previous and the subsequent speaker. So if I can have the next slide, since I think I'm now not controlling it, but maybe I am. No, I am controlling it. Okay, so I'm going to be talking a little bit about trauma and the particular diagnosis of PTSD. I'm going to be building a little bit on what's already been said about the difficulties with credibility and disclosure, which are linked to mental illness and in particular to the effects of trauma on memory and the effects of PTSD on the ability to disclose. I'm going to be talking a little bit about the emerging concept, which has now been recognized within the new ICD classification of mental illness as complex PTSD. I'm going to be touching on some treatment needs, both for people with PTSD and for people with complex PTSD. And then I'm going to try and end up with something a little bit more mainstream for a legal audience in terms of the relationship between some of what I've said and disability-based international protection claims. So just a tiny bit about the Helen Bamber Foundation, the organization that I work with. We work with survivors of torture, trafficking, and other forms of extreme human cruelty. And my clinical experience suggests that there are some important and useful commonalities between these groups. First of all, these are groups of people who tend to have suffered repeated and prolonged trauma, and that their trauma may be regarded as complex. It's not straightforward like a road traffic accident. They share a vulnerability to further trauma. Their trauma makes them more rather than less vulnerable. And they have a presentation very often, which is of what we recognize as post-traumatic stress disorder, but also of other features such as difficulties in establishing and maintaining trust, a loss of a sense of decision-making agency and autonomy, an inability to imagine a future for themselves, compared, for example, with people who are depressed, who tend to say, I know that the future is very bleak. People with this sort of PTSD in response to multiple and repeated trauma simply don't understand the question. They just don't know how to imagine a personal future. They may have a pattern of inappropriate risk-taking through their sexual behavior, their drug-taking behavior, or their self-harm. They may have physical problems which don't have a clear-cut physical cause, and they may have neurological abnormalities which are partly a reflection of somatization and partly of real neurological injury, and that may be difficult to tease out. They also tend to have important perpetuating factors. So it's not only that they have been traumatized, but the situation that they're in makes it difficult for them to recover from their trauma. They're often separated from their country and from their family. They often have long periods of immigration limbo. They're not able to work. They may become de-skilled as a result. They may go in and out of destitution as a result, and they may be criminalized as a result of the consequences of their destitution or as a result of the alcohol and substance misuse that they may be relying on as the only way of relieving their trauma symptoms. They will invariably pretty much have lost the support networks they had in their country of origin, and they may have difficulty in establishing and maintaining support networks in their host country. They may have repeated experiences of rejection and disbelief. I've already mentioned alcohol and substance misuse. Many of them will have ideas that may seem paranoid. They may think that they're being monitored, that they're being followed. And one of the things we all have to remember is that may be true. And the security forces in many countries continue, for example, to monitor opposition figures who have fled their country. They may have great difficulty in accessing medical care, in accessing legal protection, and in accessing all aspects of care, including housing. So some of the concepts that emerge from that are that people who have been severely traumatized may experience multiple and repeated loss. They may experience physical pain, and they may express their mental pain, their psychological pain in physical terms. And maybe more important than that, and over and above that, they may have an existential crisis as a result of their multiple adverse experiences. They may question the appropriateness of their continued existence. And that may be particularly the case for people who have experienced betrayal, and betrayal is very often an experience had by people who've been severely traumatized, but maybe even more important than that, they may have found themselves in positions, in situations in which they have had little choice but to betray others. And I suspect that that is something that is commoner than we realize. And that experience of betraying as well as being betrayed may be particularly damaging to the sense of self. And sexual violence is also particularly damaging to the sense of self and is often associated both with shame and with dissociative behavior, behavior in which people, if you like, zone out of reminders of the experiences which they found unbearable and memories of which they continue to find unbearable. Now, some of that has implications for people's ability to disclose fully, and by extension with the extent to which people in judgment over them who don't understand some of these problems and barriers may see as issues of credibility. Now, as a clinician, I have been reminded many times over the past 15 years or so in which I've worked in this area that it's not for me to think about credibility, although I understand that there are recent cases which have relaxed that ruling a little bit. Be that as it may, I think what is legitimate currency for me as a clinician is the notion of clinical plausibility. And that is whether their presentation hangs together, whether it hangs together as a presentation of a recognizable mental illness, and that touches on the issues of diagnosis that I mentioned earlier, but also whether things are of a piece, whether their appearance, their demeanor, their behavior, and their description of their symptoms hangs together in and of itself, and whether it makes sense in terms of the traumatic experiences that they describe. So within that, it's important to remember that although it's fairly easy for actors to feign individual mental symptoms or behaviors, the full clinical picture of a mental illness is much harder to continue to maintain over a full clinical assessment or over a period of time. So it's important for me as a clinician, for example, to look at whether what I have observed is in keeping with what other people have observed as recorded in GP notes or by other people who've written reports. There are particular problems that people with PTSD have in dealing with direct interviewing. That is even more the case where they are interviewed in an adversarial way. And one of the repeated bizarre experiences I have as a clinician writing medico-legal reports is looking in detail at the transcripts of asylum interviews and seeing the quite remarkably adversarial way in which Home Office interviewers not only do their interviewing, but carefully record the damage that they're doing in the process. Those issues are particularly important in the context of sexual trauma and the expectation that people who have been raped or otherwise sexually traumatized, their ability to disclose what has happened to them in detail, particularly shortly after it happened, may be very limited, and delayed disclosure is often wrongly thought to be an indicator of reduced credibility. So this slide tries to put that in a slightly more cartoon-like way, and the point it's trying to make is that memory is not a homogeneous function. There are different brain processes that are involved in, on the one hand, what are sometimes called cold memories, which are contextual memories. So this is an example of somebody, a Tamil victim of abuse torture in Sri Lanka. So what the context is, well, what time of day was it? What have I just been doing? Where was I living? But the things that are going around in his head, the hot memories, are things like, well, I was in an empty cell, it was dark, there was a smell of alcohol from the people abusing me, I was experiencing pain, I was feeling shame, fear, and horror. I was responding physiologically to that. My breathing was going very fast. I felt sick. My heart was beating, so it was almost coming out of my chest, and I was sweating. So those are the things that are vivid but not remembered in context. And that's the context which tends to be remembered in a very fragmented way. So the things at the top are the things that keep coming back in the here and now as nightmares or flashbacks. And the things here are the things that people can't tell you about. Were you being raped by 2 men or by 3? Was it midnight or 11 o'clock? You just said it was 11 o'clock. Why are you saying it's midnight now? Okay, so one of the concepts that I said that I talked briefly about was complex PTSD. And complex PTSD is a notion, a diagnostic notion that remains fairly soft. And it's emerged largely out of the literature on early abuse, particularly childhood sexual and domestic abuse, rather than in the context of torture. And in DSM-4, there was this idea of disorders of extreme stress, not otherwise specified, which was a sort of prequel for complex PTSD. And the notion there, which ties in with it being linked to childhood sexual abuse, is that it was a disorder of disrupted attachment. And key within it is the idea that people have difficulty in subsequently forming and maintaining normal attachment relationships. The International Society for Traumatic Stress Studies produced what I think is a very helpful definition of complex PTSD. And what they said, which is, I think, much more elegantly formulated, is that what you need for complex PTSD is PTSD symptoms, so the re-experiencing symptoms like the nightmares and the flashbacks and the intrusive thoughts, avoidance symptoms, not watching news about your country, not talking about what has happened, not talking in detail, trying to avoid remembering the terrible things that happened to you, and the hyperarousal symptoms like the being easily startled or feeling that you're being followed. But in addition to that, what they call disturbances in self-regulation, difficulty in regulating emotions, difficulties in regulating relationships, difficulties in regulating attention and consciousness, and that's where dissociative phenomena comes in, but also altered belief systems and somatic manifestations of mental distress. Now, in the newer official diagnostic systems, the DSM and the ICD, there have been changes which to some extent echo what I've just said. In DSM-5, which came out in 2013 and is the most widely used system internationally, they've added a 4th cluster. So as well as the intrusion and the avoidance and the hyperarousal, there are negative alterations in cognitions and mood. And the particular features there, which I certainly find easy to recognize in a lot of the people I see, are persistent and distorted self-blame or blame of others, and a persistently negative emotional state. And they also recognized a subtype of PTSD with dissociative symptoms, but they didn't have a complex PTSD category. ICD-11, on the other hand, does have a diagnosis of complex PTSD, which is a little bit complicated because it's not a subtype of PTSD, but a separate diagnosis, and you're not allowed to have both. And this is within the ICD system. It's the successor of what used to be known as enduring personality change after catastrophic experiences. That's not very important. What is important is that it's very much like the ISTSS classification. in that it's the core symptoms of PTSD plus 3 further symptom clusters, which they call disorders of self-organization. Difficulty in organizing, in regulating mood, difficulty in regulating one's beliefs about oneself, which tend to be uncontrollably negative, and difficulties with relationships. In terms of treatment, what has emerged over the years is a notion that treatment for complex PTSD and its predecessors, but let's call it complex PTSD, is multi-phase, has to be multi-phase. And first of all, one has to identify the hierarchy of needs that the person has, and to remember that it's their hierarchy and one needs to ask them rather than addressing what we think is most important. But in general, one is trying to provide sequential treatment, though one may have to go back and forth between an early phase of stabilization and skill strengthening to make people more safe, to make their situation more safe, so that one can go into a quite difficult and challenging phase of trauma-focused treatment, which reviews and reappraises trauma memories. Sometimes it's been called organized recounting or retelling. But that isn't enough. There then has to be a third consolidation phase in which those gains are consolidated and there is a focus on increased engagement or re-engagement in the community. So that's the context in which I think we need, from a clinical perspective, to think about what might be needed on return. So the key issue is whether return might be associated with serious, rapid and irreversible decline, intense suffering or significant reduction in life expectancy, and could denial of treatment result in that? So can denial of treatment be persecutory, or to put it another way, when does poor or absent medical care become ill treatment? Well, what about if the treatment being proposed is harmful or is dangerous? And Ali has already mentioned some examples of that, where traditional treatments of mental illness might include being shackled, being imprisoned, being exorcised, being sterilized. Or where care is deliberately denied as a form of punishment, as a form of discrimination, or as a reflection of stigma. Or where actions in a clinical setting may place a person at risk by, for example, being in a clinical situation in which data is inappropriately shared, which may increase risk of further persecution from third parties, or where denial of treatment is linked to other inhumane conditions, or where a person has to endure unacceptable conditions to avoid persecution. So what we need to remember as, I think, clinical principles are that even if someone who has been tortured isn't going to face the same torture again, even if that danger has been eliminated, it may nonetheless represent a lasting form of discrimination or complicity if they cannot access the care and rehabilitation they need to recover from their past torture. And if discriminatory denial of care or failure to establish care pathways would result in serious harm, then that can itself be a basis for international protection. So what I've tried to say in my brief talk is, first of all, that we should be thinking not just of PTSD, but of complex PTSD, to think about complex responses to complex trauma, and that the trauma doesn't necessarily have to have taken place early in life. Even if it happens in adult life, the same complex presentation of complex PTSD can nonetheless arise. So complex PTSD should be suspected, should be assessed. Prior to treatment, or as a first step to treatment, there needs to be a comprehensive evaluation of needs, and both PTSD and complex PTSD can have a profound effect on individuals' ability to recall and recount their lives, but more particularly their traumatic experiences. And finally, and most centrally to this evening's presentations, denial of care for trauma survivors can itself be a basis for arguing for international protection. Thank you very much.
Thank you very much, Cornelius. So if I just introduce our final speaker, who is Ricardo Placodero, who's Protection Officer in the Division of International Protection at the UNHCR, where he provides technical support on rights of persons with disabilities under the UNHCR mandate. Thank you, Ricardo.
Thank you, Jennifer. And just checking that you can hear me well. Yes, okay. Well, I would like to ask the audience as well their understanding and bearing with my strong Spanish accent when speaking in English, and hoping that the automatic captioning can as well capture it. I think it's struggling. Well, I would like to thank as well the authors and their organizations for this comprehensive piece of work in a very much needed area. I will share some thoughts on how this line of work could influence, but as well be influenced by other efforts happening at a global level, and always from my capacity as a actor or agent of change for disability inclusion within UNHCR. First, acknowledging, as it is mentioned in the paper, that the Refugee Convention provides avenues to be read in an evolutionary manner. And it is open to the diverse and changing nature of groups in various societies and the evolving international human rights frameworks. In this line, UNHCR has been making continuous efforts to adequately integrate the evolving scape of human rights frameworks. And just mentioning as an example, the EXCOM conclusion on the rights of persons with disabilities and refugees with disabilities as an effort to endorse the understanding of disability that was enshrined in the CRPD and applying it into UNHCR's mandate. Nevertheless, a thorough and practical analysis of the intersection between the Refugee Convention and the CRPD was and is still a clear and well-identified gap, and it is often highlighted in the testimonies and the questions coming from UNHCR colleagues working in refugee status determination across the world. The testimonies and questions that we have been receiving, or that in their own experiences as well, chatting about this opportunity, have been shared or reflect the experiences and areas reflected in this paper. And I will share as well some other examples that could be perhaps bringing some additional light. The work that has been done through a thorough analysis of cases and existing evidence will be supported, I hope. What I can do is committing within the possibilities of my role to share and promote this piece of work with UNHCR colleagues internally. Opportunities could be sharing the paper and the contents in upcoming opportunities for updates in any of the thematic guidelines on international protection and other capacity building materials. For example, reviewing the functional refugee status determination induction program, which could be really enriched by some of the examples that are reflected in this work, and highlighting as well or reflecting some of the UNHCR's internal practices, or let's say inviting us to conduct as well an internal analysis of other examples, other cases, other situations where the intersection between asylum law and disability have been observed, and including just 2 examples to illustrate this. For example, reflecting episodes of forced conscription of persons with disabilities by non-state armed groups within relevant country of origin information, including, for example, the recruitment of persons with intellectual and psychosocial disabilities for suicide attacks. This practice, which has been often shared as anecdotal evidence, has been documented, for example, in Iraq, where intelligence reports dating from 2012 reflected 30% of suicide bombings conducted by individuals, and I'm reading quotes, individuals who are mentally challenged or are suffering from psychological disorders. And the second line of cases or examples where considering the attention required when applying criteria for derivative refugee status on the basis of a presumption of dependency to households with disabilities, with members with disabilities would be required. And for example, in particular, in certain caregiver arrangements where older siblings or parents of adults with disabilities perform core responsibilities in supporting an adult family member with a disability, and therefore could qualify for derivative refugee status against what is set in the criteria, namely children under 18 or unmarried adults with disabilities. Exploring as well, and this would be an opportunity to expand the advocacy efforts that I'm sure will be linked with the developments, where before linked with the development, but as well with the dissemination of this paper, to areas that would be requiring further attention from authorities. And this would be including the need to adopt an accessible asylum registration and determination process that responds to national accessibility standards, and that considers duties that go beyond the provision of reasonable accommodation that would happen only ad hoc and upon requests when claimants would have information on, or where this information would be provided by lawyers and other staff supporting the procedures. And wanting to call to, well, the fact that reasonable accommodation duties are different from accessibility duties, and member states should put in place measures to respond to both. Perhaps a clarification, if there's time, while both would be warranting or aiming to guarantee equal access and non-discrimination, the duty to provide accessibility through universal design would be an ex-ante duty, and should be therefore built into system, processes, and facilities without regard to the need of a particular person with a disability to access, for example, a setting, a court, a police station, or any other of the facilities where asylum procedures may take place. It would therefore require efforts to build or retrofit accessibility before applicants with a disability are even identified, and as a measure to ensure equal access. Just sharing some ideas of how this could be done, as of course, as many of you may be thinking, this requires even additional measures that are already hard to identify. But some of the practices that have been shared at the global level or in other regions would include conducting comprehensive accessibility audits in reception areas, courts, police stations, and other settings where asylum procedures may take place, and acknowledging that most persons with disabilities indicate that access to justice is impeded very often by the lack of accessibility of these environments, courts, etc. Something that has been reflected, for example, in the UN flagship report in 2018, and as well being the accessibility of reception areas, one of the less supported areas in pledges shared by states during the Global Refugee Forum, which brought together a multiplicity of stakeholders to bring forward the Global Compact on Refugee, where there's a specific mention to improving the accessibility and adequacy of reception areas based on age, gender, disability, and other diversity characteristics. Noting as well as a potential opportunity that the lack of accessibility, reasonable accommodation, and support measures at border crossing places, reception, and accommodation facilities is progressively reflected by the CRPD committee in its concluding observations to member states, and the potential for the use of this human rights monitoring mechanism pathway to raise this issue formally at the national level. Of course, highlighting that these efforts should be done in collaboration with persons with disabilities and could be coordinated by national organizations of persons with disabilities, learning from other international efforts. An example, and I could share some of the links of the documents that I'm mentioning. An interesting resource that could be accessed is the Inclusive Courts Checklist, which has been developed by the G3 ICT platform, which is specialized in digital accessibility and outlines area to support the digital transformation that is accessible and inclusive, which is as well mentioned in the report as a key area of improvement. And finally, in this line on improving accessibility, considering putting in place additional measures that precede the potential request for reasonable accommodation, including employing sign language interpreters at courts, establishing standby teams of disability experts, establishing services for services by special investigators and speech language pathologists in support of communications in processes involving persons with intellectual disabilities, for example, and producing documents in easy language prior to their demand by a particular individual requiring it. Let's say, upgrading the threshold of information accessibility as well before it is even required in a specific moment, and as well introducing which would be the possibilities of accessing additional support, which is many times ignored by claimants. Just to close, I would like to as well underscore that these measures would strengthen the international call to efforts for the progressive abolishment of or reduction at the least of substitute decision making in all asylum procedures in favor of supported decision making for persons with disabilities, and looking as well at the standards and the recommendations that have been put forward recently by the Office for the High Commissioner on Human Rights with the international principles and guidelines on access to justice for persons with disabilities, which I can as well link or hyperlink in the chat. To close, I would like as well to highlight, thank everybody listening to this webinar and highlight their crucial role that they can have in as potential entry points for persons with disabilities who are unaware of which are some of the protection systems existing in country. So looking beyond the asylum process and connecting as well on how they can support their integration in country, and sharing information on protection systems, benefits for persons with disabilities, but of course the criteria and the process that would be needed, and sharing as well where criteria would be exclusive for claimants with disabilities or asylum seekers or refugees, including where they are receiving already benefits that are linked to their status. And information as well on local organizations of persons with disabilities who could provide peer support. In this regard, one of the recent examples that I think would be interesting to duplicate in other states would be in Sweden, the project done by the Independent Living Institute. The project was called Disabled Refugees Welcome and Produce Materials, but as well support and orientation sessions for migrants, asylum seekers, refugees with disabilities who were in Sweden. With this, I would like to thank again the organizers of this event, and for giving UNHCR an opportunity to share some thoughts about this work. Thank you so much.
Thank you so much, Ricardo. That's amazing. I just want you to come and live in my office and tell me all your clever ideas. That was brilliant. I think you mentioned sharing some links in the chat, so maybe we'll send around some links afterwards as well with slides and things like that. So I don't know if anybody has any questions that they'd like to type into the Q&A, and we can put them to the speakers now. Perhaps I could start with a question and see if our we've got one come through, but I'll start with one just to say maybe to anyone in the panel who wants to, what do you think would be? I mean, do you think there needs to be obviously a series of small measures, but to what extent do you think there needs to be a major cultural shift or legal shift in the way that disability is treated in asylum cases? What kind of first step might people listening to the webinar today look at taking themselves in their work, or in kind of legal campaigning work around it, if anyone has got any ideas? Ali, are you still on the call? Or David, do you have an idea?
Well, it seems to me that, as I said at the outset, what we really need to do is integrate an understanding of disability and mental health into every aspect of what we do throughout our work, because one thing that's really been enlightening, I think, about this evening was Cornelius's fantastic talk about complex PTSD and the way in which complex PTSD differs from PTSD, and the way that this is something that we should be looking out for as practitioners in people who've had repeated or severe or early trauma. And I think that's absolutely right. I think we need to be, as practitioners, building mental health literacy. Now, speaking for myself, I do a lot of work with Albanian asylum-seeking children and young people. They're a group who's treated particularly poorly by the system. There's been in the past a prevailing attitude that Albanian claims didn't have merit, which is completely wrong. We've put out a number of resources on the Garden Court and Miklu websites about how you can take on and win Albanian asylum cases. But one thing that we've really had to do in the course of doing that work is integrate a real understanding of mental health and trauma and depression, and how it, and particularly childhood trauma, and how it intersects with the asylum process. You're working with a highly traumatized population who've often been kind of re-traumatized by the immigration system, by being disbelieved, by having their claims refused, losing their appeals, and sometimes being pushed into the shadows and pushed into living underground. and in some cases exploited in that process. So I think we need to integrate mental health literacy into everything that we do. I think all solicitors need to have specific training in working with traumatized clients, and I think this needs to be core to the way that we're approaching casework. And one thing that both Cornelius and I touched on is everyone needs to understand that when you go through a Home Office refusal letter and you see them saying, well, you said here it was the 23rd of December and here you said it was the 24th, so you're not credible, alarm bells should be ringing that is nonsense, that's something we should be rebutting through appropriate evidence.
It's interesting when you look at lawyers working in other areas of law, so for example, kind of court of protection or something like that, where the process is a lot more collaborative and there is more maybe of an intersection between sort of different professionals coming together to find a route forward, rather than the kind of hostile and rushed approach we're used to seeing in the asylum system.
Since we're a bit short of time, can I answer a couple of the questions from the Q&A?
Yeah, so we've got this one from Brian about whether we need to review the Refugee Convention itself. So whether the issues stem from the requirement of the convention to kind of fall within a particular social group, or whether we need to review the Refugee Convention altogether, looking at the social model of disability under the UNCRPD. David, do you want to have a go?
Yes, by all means. So I think there's a number of levels on which we can answer this question. Like every other international treaty, the Refugee Convention is the product of political compromise. It's now quite old. And of course, it is in many respects an unsatisfactory instrument. And of course, it is also designed for a world with borders, and it's designed to discriminate between quote unquote genuine refugees and quote unquote economic migrants or people with other reasons for migrating. Now, so there's a number of ways in which we can approach this question, therefore. One is to take the blue sky approach and say, should the Refugee Convention be replaced with something else? And my answer to that would be yes. I personally don't think we should have immigration controls at all. I think we should have a borderless world. But in terms of, obviously that's not realistic, and I don't think we're going to see realistically any new international treaty with significant global acceptance coming in to supplant or replace the Refugee Convention. Obviously, the Refugee Convention is supplemented by regional instruments like the EU Qualification Directive that provides for subsidiary protection that's wider in certain respects than asylum. The other thing is that, as Ricardo said earlier, the Refugee Convention is a living instrument. The Refugee Convention is a living instrument, and of course the interpretation of the Refugee Convention has evolved over time and is not the same in every country. But in UK jurisprudence, certainly the Refugee Convention jurisprudence has evolved to, for example, take account of sexual orientation as a basis of persecution, and that's now a very, very well accepted and familiar concept, and we see asylum claims by LGBT people all the time. So so I think, sorry, that was a bit of a rambling answer, but I think the short answer is this: is the Refugee Convention unsatisfactory in some respects? Yes. And as I say, I don't think we should have immigration controls at all. I don't think there's any way of having a non-oppressive border system or immigration system or asylum system. But insofar as the Refugee Convention is a powerful tool for getting good legal outcomes, I think it absolutely is. I think, as Ricardo says, it's a living instrument, and we can see how the interpretation of the Refugee Convention has evolved over time in national jurisprudence. We can also see how it's been supplemented by regional instruments like the ECHR and the EU Qualification Directive that provide wider protections in some respects. Anyone else?
Yeah, this is Ali. Sorry, I keep my Wi-Fi is playing up, so I keep on jumping in and out. I agree with everything that David has said, and I think the Refugee Convention is sufficiently flexible, given the correct approach to interpretation of the convention by reference to the Vienna Convention, to accommodate protection claims based on disability, specifically by interpreting the elements of Article 182, for example, in a way which not only maybe expands the scope of protection, but also changes the way in which we look at the content of the law. So if we go back to looking at cases like Shah and Islam, for example, where we look at non-state actors perpetrating harm, family members, one on another, and the way in which that was posited in the context of looking at structural and social discrimination towards women, and we look at the outcome in that case, we now take it for granted, perhaps, but at the time it was a pretty radical way to approach protection claims brought by women who fear violence at the hands of family members. So if I have a case, for example, in the upper tribunal at the moment where a severely disabled man, wheelchair bound, who needs 24-hour care, will suffer inhumane and degrading treatment through the neglect of his family. So not by a positive act of intentional physical violence, but through, I suppose, positive act of neglect. And the question for the tribunal will be, does that constitute persecution? And so that's going to raise questions about the way in which we conceive persecution, and also about the way in which we conceive protection. And that will require the tribunal to assess the appropriate standard for people like my client who is severely disabled. And the way to do that is, as David touched on, to do it to approach the question by reference to the applicable international law standards, and those are found, in my view, in the International Convention that prohibits discrimination towards disabled people. So it's not simply, I suppose, a question of looking at just the bare text of the convention, or even simply looking at the way it should be interpreted, but beyond that, looking at other sources of international law and international law norms, and weaving them together in a way that sets standards. So you're engaged in a form of standard setting, and a new way of a new form of standard setting to understand how best to provide protection for this group of individuals, just as it was done for female victims of domestic violence fleeing countries like Pakistan.
And I think that goes some way to answering the other question we've got in the chat from Thompson Law about the boundary between a particular social group sort of based refugee convention claim and an Article 3 ECHR case which would get you kind of 30 months leave to remain and much less stable status and protection. I guess the point to make is that the boundary isn't that clear, and it's not going to be one thing or the other necessarily. So you might get a case that could be framed in either way, both ways, or some cases that can't. But I guess it's about, as you were saying, Ali, about how you frame, conceive, explain where the persecution lies.
Yeah, I want to jump in the couple of minutes we've got left, just to respond to the question by Thompson Law in that regard, because in terms of how we would differentiate between a particular social group claim and an Article 3 medical case, Article 3 medical, in the sense of Paposhvili and AM Zimbabwe, is about where you would suffer death or severe suffering because of lack of adequate medical care, essentially. So it's a so it's essentially a negative rather than positive act. The state wouldn't provide you with adequate care on return. But for a lot of disabled people returning, it's not just going to be about adequate medical care. It's going to be about, for example, if somebody's got a mental illness that leads them to act in a disinhibited way or to have delusions, they might behave in ways that will cause them to be assaulted or detained or ill-treated by police, assaulted or ill-treated by members of the public. They might, as Cornelius and Ali touched on earlier, they might be sent to an abusive psychiatric hospital where they're going to be chained up. They might be sent to a traditional healer or shrine where they're going to be chained up and ill-treated. So there's going to be positive acts of the state or non-state actors doing some form of violence or inhuman treatment to them. And that's not an Article 3 medical claim. That's not a Paposhvili claim. That is potentially an asylum or humanitarian protection claim. And as Jennifer said, the difference is very important, because if you win on Article 3 medical, all you're likely to get is your 30 months limited leave. Whereas if you win on asylum or humanitarian protection, you get 5 years leave with a path to settlement. You get a much more favourable status. So that's the distinction. It's if the persecution you would face is if the problems you're going to face is not just lack of healthcare, but also people doing things to you, whether it's forced institutionalization, forced inhuman forms of medical treatment, or detention, assault, sexual abuse. If as a disabled person you're going to be vulnerable to those forms of treatment, then you're in the territory of asylum and humanitarian protection. It's not just an Article 3 medical case. And Cornelius had a slide earlier where he listed some of the ways in which treatment might itself amount to persecution.
So that's great. Thank you so much, everybody. Thank you for all our speakers for coming along and speaking today. It's really, really interesting. And I hope it has been something where we've started a conversation we can carry on. I was talking to Ali earlier about how nice it would be, once face-to-face stuff is more possible, to have some kind of like symposium or thinking space to think through some of these ideas and kind of get some things moving. So hopefully we can look at following this up in the future. But at the moment, thank you so much for Garden Court Chambers for hosting this webinar. It was very, very kind of you, and you're much more technically competent than I am. And thank you so much for Ricardo for coming and joining us today, and to all our other speakers.
Yeah, many thanks to Amy from Garden Court for looking after the technical side. It's all gone very smoothly. And thank you to everyone for coming and for the excellent questions that we've had. I'm sorry that we didn't get time to answer everyone's question. And thank you very much to Ali, Cornelius and Ricardo for volunteering their expertise and insights with certainly perspectives that Jennifer and I wouldn't have been able to provide on our own.